That's
laws
exactly what the cases say.
Oh,
I mean, I thought that's what the cases say. If it deals with arms, and this is what Heller Part 3 says, then the government comes in and shows there's a historical tradition. And to get ahead of all this, Heller actually went through and specified a number of kinds of regulations that would be permissible because they are so broadly and deeply rooted. At least, I mean, what's wrong with that reading of our precedent?
Because then it would really, as the Everytown brief says, threaten gun regulation more generally in ways this court has so far not reached, because you have all sorts of times in which, like take the 922 statute, 11 different categories of things that are singled out as gun regulation. If every single time the state had to defend the burden on each of those things and say, you've got to find historical analogs, that really does undo, I think, the much more limited nature of the inquiry that Bruin recognized.
Mr. Katyal, I thought your answer to Justice Barrett and Justice Kavanaugh is that really step one is trying to help us to understand what the scope of the right is.
Correct.
The Second Amendment right. Is it really being implicated here?
Correct.
And so that when you have a situation like this one, in which there is broad consensus, everybody agrees that there is some limit to the Second Amendment right, and you read a case that said that limit was geography in the sense that you don't have a Second Amendment right to bring your gun onto someone else's private property. They have to consent for you to be able to do that. We have already limited the scope of the Second Amendment right for purposes of this discussion, because we're talking about a right that doesn't just freely exist. So in the Chief Justice's leafleting example, it's similar. Like, I don't see the Second Amendment operating differently than, say, the First Amendment, because in the leafleting example, the reason why you get to go up to the person's door is not because you have a First Amendment right to do that. You get to go up to the person's door because there is a custom and tradition of implying the person's consent for you to do that in that situation. That all the states, everybody says, when you come for the purpose of passing a leaflet, we are going to assume, we're going to imply that the owner is allowing you to do that. He doesn't have to put up a sign that says, please come. We're going to, but it's operating around property rights, not that your First Amendment right is what is getting you onto his property. Similarly, the Second Amendment right is not getting you onto someone's property in this way. If it's a private property, even the property open to the public, it's the implicit consent that many states have allowed that is what is doing the work of allowing you to carry your gun in that gas station. Am I right about that?
That's exactly right. And the one thing I would add is that what I think is doing the work in my friend's argument is some sort of insinuation that Hawaii has singled out and is hostile to guns or the Second Amendment and the like. And I point you to two reasons why that's wrong. Number one, Hawaii has these very same laws about implied consent and changing the default rules for other things besides guns. So 445.115 has it for cards and banners and placards, akin to the example that you're mentioning before. 339.4 is about litter and bringing it on. 291C is about vehicles.
And what you're saying, I think, is that there is no Second Amendment right to assume implicit consent.
Yes.
There is no, to the extent we're talking about, is this about consent? And I think we are, because you don't have a right to go on without consent. Then is the Second Amendment doing work with respect to allowing you to say, I have a constitutional right to assume that I'm allowed to be here? And you're saying they have no case, no history, no nothing that establishes that principle.
That's exactly right. And the other thing I'd point to about this motivation attack by my friend on the other side is that, Hawaii, the legislature took Bruin seriously. This statute's all about making sure the right of Bruin is vindicated. And just last year, for example, Hawaii issued 2,207 concealed permits for firearms. They only denied 119 applications, and the majority of those were denied because people didn't fill out the application in full or they got it out of time.
Thank you, counsel.